Chapter 3 Composition of Arbitral Tribunal Section 10 to 15. Consider the following statement. Which one above is true or correct? Parties may choose mid-arbitrator as the procedure for settlement of their dispute. There must be pre-existing written agreement of arbitration for dispute settlement by arbitration. Within how much time the two appointed arbitral will have to appoint the third arbitrator? Within 30 days from the date of their appointment. The parties to an arbitrator are free to determine the number of arbitrators, provided that such number shall not be an even number. An arbitrator may be of any nationality unless otherwise agreed by the parties. If there is no agreement between the parties to an arbitration proceeding in respect of number of arbitrators, there shall be one arbitrator. In a suit for specific performance of an agreement of sale of immovable property, the defendant, along with his written statement, file an application under Section 8 of Arbitration and Conciliation Act for referring the party to an arbitration in accordance with the arbitration clause contained in agreement to sale. The plaintiff admit that existence of arbitration clause as well as the subject matter of suit is subject matter of such arbitration clause. The court shall allow the application and refer the party to the arbitrator. On allowing the application under Section 8 of Arbitration and Conciliation Act, the suit stand disposed of. A suit to challenge the appointment of person as arbitrator by the defendant on the ground of circumstances giving rise to justifiable doubt to his independence or impartiality, by seeking a decree of declaration of the appointment as null and void, and permanent injunction restraining arbitration proceeding is not maintainable. Under Arbitration and Conciliation Act, the mandate of arbitral tribunal terminates. All of the above. When the arbitral withdrawal from his office, the party agreed to terminate the mandate incompetency of arbitrator. Any person aggrieved by an award of motor accident claim tribunal and can prefer appeal to the High Court. An application under Section 11 of Arbitration and Conciliation Act 1996 can be filed either in Supreme Court or in High Court. An arbitration agreement dated 1st December 2018 provided for the reference of dispute of 4 arbitrators, with 2 to the appointed by each of the parties. The arbitration agreement is to be constructed as being a reference of dispute to the sole arbitrator. In an arbitration between two parties, before an arbitrator appointed by Chief Justice of High Court in exercise of power of Section 11 of Arbitration and Conciliation Act 1996, the rival party have filed claim against each other. When arbitration was at advanced stage, the party or opinion at arbitrator is likely to reject the counterclaim of both the party. The parties jointly inform the arbitrator that they are not willing to arbitration before him and stop appearing before him. The parties thereafter are entitled to appoint another arbitrator and to start arbitration proceeding de novo. A party seeking appointment of an arbitrator through the High Court or its designated shall make a request under Section 11(6) of Arbitration and Conciliation Act. A nomination of an arbitrator is made by a person who is himself ineligible to act as an arbitrator under Section 12 subclause 5. Read with the 7th schedule to Arbitration and Conciliation Act. In such case, the nominee cannot act as an arbitrator, shall such a nomination would be void ab initio. Who can appoint the arbitrator pursuant to arbitration agreement with reference to dispute to a solo arbitrator? Both 1 and 2. The party to arbitration agreement or a person, body, if any mentioned to an arbitration agreement, the court or any party or institution designated by such court. Arbitration agreement provided for arbitration by 4 arbitrators is under Arbitration and Conciliation Act 1996 to be constructed as an agreement for arbitrator by sole arbitrator. If within 30 days the parties fail to appoint their arbitrator or arbitrators fail to appoint the third arbitrator, the arbitrator shall be appointed by Chief Justice or a person institution designated by him. In the arbitrator proceeding, where party failed to appear and at an oral hearing failed to produce documentary evidence, the tribunal has a power to continue the proceeding and to give its award. Arbitration award rendered in arbitration proceeding commenced before and coming into force of Arbitration and Conciliation Act are to be challenged as per the provision of Arbitration Act 1940 only unless otherwise agreed by the party. The arbitrator in the case of international commercial arbitration is appointed by both A and C, the party themselves, the Chief Justice of India.